Many farmers, though, do rely, as you heard, on that H-2A temporary ag worker program for assistance with everything from planting to harvest. The Department of Labor actually recently published a final rule designed to enhance protections for workers under this program. Roger McEowen with the Washburn School of Law joins us now for more on this. And Roger, I don't know if you just heard that piece right before you, but boy, it is a struggle out there. Obviously, there is a lot to this report. Ultimately, this is going to help safeguard workers. But what stands out to you with this?
Well, good to be with you, Suzanne. What stands out to me, in line with the comments of the previous commenter, is that this is another set of regulations that may end up negatively impacting certain farming operations, even though it's designed to provide additional worker protections. Of course, the H-2A worker program is the program that helps employers who anticipate a lack of available domestic workers. And so under the program, foreign workers that come to the U.S. to perform temporary or seasonal ag work for planting, cultivating, harvesting, that type of labor are covered in the program. And so the new rule, which becomes effective in a few days, June 28, its stated purpose is to increase wage transparency and clarify when an employee can be terminated for cause, but it sets up a labyrinth of requirements that employers have to go through before they could terminate someone for cause. And there are also expanded transportation safety requirements and new employer disclosure requirements and new rules for worker self-advocacy under the rule.
So it sounds like the impact, too, for producers and farmers right now, there's going to be a lot more paperwork, a lot more logistics. They're going to have to jump through a lot more to make sure those workers and they're following the law of this, right?
Yeah, that's right. That's going to be the major impact on farm employers in this situation, because if you have a worker that's employed under the H-2A program, they have a right now, when the new rule takes place, to be paid 3/4 of the hours offered in the work contract, even if the work ends early, and housing and transportation until the worker leaves. And then payment for outbound transportation has to be provided by the employer. And if the worker's a U.S. worker, they have to be contacted for employment the next year unless they're terminated for cause. So you're locked in for the next year. And as I said, you can only terminate a worker for cause after you go through a whole bunch of warnings and procedures and write-ups and all of that. And there are 5 conditions under the new rule that have to be satisfied to ensure disciplinary or termination processes are justified and recoverable. And if you're moving them in vehicles, those vehicles have to be manufactured with seat belts. And the employer has to maintain, not only maintain, but retain and maintain those seat belts in good working order and prohibit the operation of a vehicle unless each worker is wearing a seat belt. So that's a new requirement.
There is a lot to this. Everybody's subject to this new rule as long as they have H-2A temporary workers. And do you expect any legal challenges as we move forward with this?
Yeah, well, yeah, I do. There may be some constitutional issues that are involved here, and every farm operation that uses the program and hires a worker under the H-2A program is going to be subject to the rule once they make an application for H-2A employer certifications that are submitted to the Department of Labor after on or after August 29. Now, the rule takes place June 28, but it only really starts applying after August 29. And like I said, I think there will probably be legal challenges for it, but in lieu of that, employers better be familiar with these new rules and be ready to comply with them pending the outcome of any potential legal litigation that might follow.
Well, just a lot more challenges lying ahead for our producers. Thank you so much, Roger. With all of this, I appreciate you, as always, being here and breaking it down for us. Roger McEowen with the Washburn School of Law. Always a pleasure.